Formation of LLP, Limited Liability Partnership, in India. By CompanyLegalGroup.com. The Indian Corporate Law and Corporate Governance Consultants. What is limited liability partnership? It is important to understand the difference between limited liability partnership firm and similarity is must in order to select right legal entity. Difference between a company and LLP in India. Documentation. Company memorandum is to be filed with ROC. LLP incorporation document is required to be filed. Flexibility regarding registration office of the company. Company memorandum should contain state in which incorporated. LLP incorporation document is not required to contain state in which incorporated. Thus, registered office can be changed to any place in India just by informing ROC subject to prescribed conditions. Nomenclature. Company name to contain limited or private limited as suffix. LLP name to contain limited liability partnership or LLP as suffix. Submission of main documents regarding LLP. Company articles are to be filed at the time of incorporation. Private company must have articles. In case of public company, provisions of Table A apply, if there are no articles. LLP agreement is required to be filed later. In absence of LLP agreement, mutual rights and duties will be as specified in First Schedule to LLP Act. Thus, practically, each LLP must have LLP agreement, though not mandatory. Management team. Company managing director and whole-time director to look after day-to-day administration. LLP designated partner to look after statutory compliances. Otherwise, all partners can look into affairs of the LLP. However, LLP can delegate powers to some partners who may be designated as managing partner or executive partner or any other name. Management of the firm. Company individual director or member does not have authority in conduct of business of company. LLP every partner has authority to conduct business of LLP unless the LLP agreement provides to contrary. Remuneration. Company restrictions on remuneration to director as per Companies Act. LLP no restriction on remuneration to partner. Remuneration should be provided in LLP agreement. Change in management. Company notice of change of director is to be given by company. LLP a partner who has resigned from LLP can himself file notice of his resignation to ROC. Share certificate etc. Company share certificate, register of members, transfer and transmission of shares etc. required. LLP no requirement of share and share certificate. Hence, no question of its issue, allotment, transfer, rectification of register etc., conduct of business. Company board meetings, general meetings are required. LLP no provision for regular meeting of board and members. Partners can decide when and how to meet, delegation of powers etc. Provision is made that LLP should maintain minute book. Treatment of secured loan. Company charges are required to be registered. LLP no provision for registration of charges. Maintenance of records. Company elaborate records and registers are required to be maintained. LLP no records and registers have been prescribed. Restriction on board or partner. Company restrictions on board regarding some specified contracts in which directors interested, investments, loans, and guarantees to other companies. LLP partners are free to enter into any contract. Disclosure. Company disclosures required of contracts where directors are interested. LLP, no requirement of disclosures required of contracts where partners are interested unless specified in LLP agreement. Provision relating to redressal. Company, elaborate provision relating to redressal in case of oppression and mismanagement. LLP, no provision relating to redressal in case of oppression and mismanagement. Specific provision. Company, specific provisions relating to NITIS, NBFC. LLP, no specific provisions relating to NITIS, NBFC. Visit us at companylegalgroup.com.